Chair, may I bring up my panel? Yes, great. Hi there. Hi, how are you? Good afternoon, Mr. Chair, Mr. Vice Chair, members of judicial proceedings. Senator Sarah Love here to present SB 827 relating to where and how we house children in the correctional system. This is the first of 3 bills that I have that have a common theme. They have to do with restrictive housing. They have to do with how we treat our people in prisons, and they have to do with our correctional system overall. So this bill is directly related to, as I said, how we house our children. Earlier this session, we heard the chair's bill regarding charging children as adults. On top of charging children as adults is the issue of where you house these children. Right now, because these children are charged as adults, they are being housed in adult facilities. I want that to sink in for a minute. Children are being housed in adult prisons. Federal law requires that when a child is in an adult facility, they have to be separated by sight and sound from those adults. Prisons built for adults, by definition, are not equipped to handle children. So what happens is these children are being held in restrictive housing. These children are held in cells by themselves or with another child for most of the day. They do not get access to programming. They do not get the services they need. So SB 387 does 3 things. First, it requires all juveniles charged as adults be held in a juvenile facility unless that child is released on bail or on other conditions of release. Second, it prohibits the detaining or confining of children in adult facilities. Full stop. Finally, SB 827 builds on the work this committee has done regarding placing limits around putting children in restrictive housing. It prohibits a minor being placed in restrictive housing solely for the purposes of discipline, punishment, administrative convenience, retaliation, or staffing shortage. A minor may only be placed in restrictive housing as a temporary measure if there is clear and convincing evidence of an immediate and substantial risk to the minor, other incarcerated individuals, staff, or the security of the facility. In its testimony, DJS says it only places kids in seclusion for 1-hour increments with other procedures that may be followed. I am fine if we want to take that language and codify it. Finally, in addition to the extremely important purpose of not harming our children by placing them in adult prisons and/or restrictive housing, SB 827 has another very important purpose. It would bring us in compliance with federal law. Maryland is currently out of compliance with federal law because we house too many children in adult facilities. As a result, we stand to lose upwards of $500,000 over in each of the next 2 years in federal funding. So by passing SB 827, we can help our kids and come into compliance with federal law. I have been working with Vice Chair Bartlett, who is my cross-file on this bill. We will have a number of amendments for you. You don't have them yet, but you will have them shortly. For these reasons, I ask for a favorable report of SB 827, and I will hand it over.
Good afternoon, Mr. Vice Chair and members. Thank you for the opportunity to express support for this important bill. My name is Emily Virgin, and I am the Director of Advocacy and Government Relations at Human Rights for Kids. As the Senator said, this bill seeks to protect children fully against solitary confinement in 2 ways: by placing strict requirements on its use while still allowing for a temporary cooling off period, and by prohibiting children from being placed in adult facilities. For children in DJS facilities, current DJS policies meet or exceed these requirements, and we applaud those policies, but administrations change, policies change, and so codifying these practices in statute is the best way to protect Maryland children going forward. Prior legislative efforts to end solitary confinement for children in Maryland, while they made huge strides, did not fully protect children. The bill in front of you today, however, would fully protect children because it removes children from adult jails. Maryland still allows children 30 to 40 on any given day to be held in adult facilities, and federal restrictions, as the senator mentioned, prohibiting children from having sight and sound contact with adults in those facilities means that when children are there, they are in what amounts to solitary confinement. The effects of solitary confinement on the mental health of a child who is being held in an adult facility in particular are devastating, and they have led to the suicide deaths of children across the country. Children who are held in adult facilities are 36 times more likely to die by suicide than children who are held in juvenile detention facilities. Khalif Browder is one such case. He died by suicide after being subjected to solitary confinement as a 16-year-old in New York. That case was high profile, but just last year, a 16-year-old girl named Kaylin Drake died by suicide in an adult jail in Mississippi. We implore this committee to not wait until something this devastating happens in Maryland to take action. We urge a favorable report.
Good afternoon. Thank you, Vice Chair Waldstreicher, and committee members for this opportunity. I'm Ryan Ross, President of the Maryland Correctional Administrators Association and Director of the Charles County Detention Center. I'm here today in support of Senate Bill 827 with amendment. The intent behind this bill is crucial. It seeks to ensure that children, including those under adult criminal court jurisdiction, are not housed in facilities where they are within sight and sound of incarcerated adults. This is essential for their safety and rehabilitation. Local adult correctional facilities are not designed to house juveniles. They are built to accommodate adult offenders, and their architecture does not allow for proper sight and sound separation between adults and juveniles. While some of these facilities could, in theory, make infrastructure changes, the construction cost of new wings and sections would be upwards of $30 million for each of the jurisdictions in Maryland. Understandably, staffing and program costs would parallel. That said, retrofitting adult facilities is not the best or most efficient way to address the needs of juvenile offenders. Currently, juveniles who are initially booked into adult facilities and court-ordered to be transferred to juvenile facilities routinely remain in adult facilities for days or even weeks awaiting transfer approval from the Department of Juvenile Services. During this time, juveniles are often placed in the only facility areas that are able to support sight and sound separation, restrictive housing. To maintain this approach is neither ideal nor conducive to rehabilitation. Instead of trying to retrofit adult facilities, we should focus on creating and expanding juvenile facilities designed specifically for young offenders. These facilities would meet the unique needs of juveniles, providing age-appropriate programming and ensuring that they are kept separate from adult populations. This approach will ensure I respectfully urge the committee to issue a favorable report on Senate Bill 827 with amendment. Thank you for your time and consideration.
Thank you.
Thank you to the Vice Chair and members of the committee for having me. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support Senate Bill 827. I'm going to say a big thank you to the sponsor of this bill. There have been other versions in the past that may go to oppose, but after keeping an open dialogue with sponsors and really staying in touch with advocates as well, we think that the bill is in great shape now. And I think that it speaks to some of the limitations that we have in our spaces in our local facilities, and it really grapples with those realities. And sometimes I think it's frustrating when there's legislation that doesn't, which is why we really, really appreciate that this is going in a direction of making sure that juveniles end up in facilities that are appropriate for them. So we support this big time. Thank you so much for bringing it. We would urge a favorable report. Thank you.
Great. Thank you to the sponsor and her panel. Questions for this panel. Senator West.
Thank you, Mr. Chair. Just a quick question for the sponsor. I'm looking at the opposition filed by the Department of Juvenile Services, and you talked about the first paragraph of the opposition and said you'd be happy to amend the bill to make it in accordance with what they suggest in the first paragraph. I think that's a good idea. But the second paragraph talks about putting juveniles into adult correctional facilities. And they say, although DJS believes that no youth should be placed in adult correctional facilities, without other statutory changes, the proposed framework will result in overcrowding. And I wondered, do we have any information about that? In Baltimore County, I know the Hickey School, which I've toured, is not overcrowded. There's ample room for more juveniles there. And occasionally a juvenile gets put in the Baltimore County Correctional Center. And when that happens, typically he's the only one juvenile there. And so it's almost like being in isolation for the whole time he's there. So at least in Baltimore County, I don't see an overcrowding problem. Are you aware whether any place else in the state there is an overcrowding problem, which would prevent juveniles from being housed in juvenile facilities until the trial?
It's a great question. Thank you, Senator West. I don't have that information. Perhaps DJS can get that for us.
It would have been nice if they'd given it to us.
It would have been, yes.
Okay.
Thank you.
Maybe we can go back to DJS and ask for that information before we vote on this bill. Thanks.
Of course, Senator James.
Thank you, and I have a question for you too, Senator Love. Thank you for bringing the bill. So I was reading the Maryland State's Attorneys Association. I don't think they're opposed, but they're highlighting something that I think is important, and I haven't read the entirety of your bill to see how it would be addressed. So they say, look, in current Maryland law is that juveniles that are charged as adults that are eligible for transfer with the exception of juveniles age 16 or 17 charged with murder in the first degree, or juveniles previously convicted as adult, which I'll ask you about in a second, should be in juvenile settings with 3 exceptions. Only the third one really matters to us. One is that they're released. 2 is that there's not available space for the juvenile in a facility. Don't know how your bill addresses that. Like, let's say we don't have capacity, what would we do? But I think the one they're most concerned about is this. Detaining the juvenile in a juvenile facility would pose a risk of harm to the juveniles or others. This exception is important, they go on to say, because they have witnessed and dealt with numerous severe, violent encounters with, very, very violent juveniles, let's say a 16 or 17-year-old, in there with a 14-year-old that's in for a different reason. So how does your bill address that?
I'm actually going to turn that over.
That's fine. I was, if you wanted to answer it, you could. All right.
Yeah, so I'll start with those 3 sort of exceptions are current law.
Right.
And so they're speaking to the 3rd exception. All of those exceptions are currently utilized to continue to hold children in adult facilities. And what we're trying to do is remove children from adult facilities, full stop. And what I'll say is that currently, as far as we can tell, there's no rhyme or reason in terms of which kids who are in adult facilities are taken from adult facilities into juvenile facilities, other
really
than
think there's no
other than
rationale?
capacity, other than DJS saying we don't have room right now.
You don't think it has anything to do with violent propensities of the juveniles?
As far as I have not been told that.
I'll ask them.
And so what DJS has told us is that they feel confident that no matter the offense, no matter the severity of the offense, they can handle those children. Aside from the capacity issues.
Is that letter in here? Oh, I guess it is, right? That's in here.
Well, I think in the DJS, in their testimony, they don't say, we can't handle these kids because of the severity of their charge. We can't handle them because of capacity issues. And so what their testimony says is we can handle any kid regardless of charge. And they are right now, actually almost 60% of the kids who are in DJS detention right now are kids who are charged as adults and are awaiting a transfer hearing. So they are housing a lot of kids who are charged as adults currently. So the severity of the offense, I think they are well set up to handle children who are even, who have behavioral issues, who are charged with very serious crimes. And the bill does still allow for restrictive housing in temporary circumstances. And so if there is a behavioral issue that arises, they still can utilize restrictive housing, and they can separate the child from the so-called general population.
Very helpful. Good to hear your thoughts. I'll ask them also. So then just the other related question, which I hope you'll read this state's attorney's letter, but they're saying that, look, like I said, under current law, juveniles charged with adult that are eligible for transfer, which is most of them, with the exception of juveniles age 16 or 17 charged with murder in the first degree, or juveniles previously convicted in adult court. So they seem to single out those two intense categories. What does your bill do with that? And again, I'm worried about juveniles that are to be exposed to very violent juveniles, or like that have committed murder in the first degree, or have been charged and convicted as adults before. So what does your bill do to that limited but important population for the rest of the juveniles trying to get services?
Yeah, so the current status of things is that those kids could be in juvenile facilities, and sometimes they are. And so it really comes down to the wait times of a child that is tried as an adult and waiting for a transfer hearing to start. That's what sort of causes the backlog. And so those children who are charged with those serious offenses could be in a DJS facility right now. And DJS has told us we can handle kids the way that our facilities are set up, the way our detention facilities are set up. We feel able and equipped to handle those children.
So I'll ask them, and then you can follow up because it's getting late. I'm just curious, how is DJS, we even separate when you have a combined school, middle or high school. We pretty much put the middle schoolers over here and the high schoolers over here. It's obvious.
Right.
Same with this. I think there's populations within a juvenile facility that have to remain separated.
Yes.
Right? We don't want to take chances here and traumatize children any further. So is that what your understanding is, that currently our facilities for juveniles, the most serious offenders, very violent histories, are kept quite away from the rest of the population? Is that your understanding?
It is indeed my understanding that when you have older children, that they are separated from younger children. And so
age is one thing, violence is
severity.
another, though. So I think
Yes.
we're in a whole different category on violence.
Yeah, absolutely.
So they're separated.
Yeah, they absolutely can be. Yes.
Yeah, I wouldn't just do age. I would think a 16-year-old that is in there but is not there for violence, is next to and are surrounded by numerous 16, 17-year-olds that are for violence. That's a recipe for high risk. You'd agree, right?
Yeah, absolutely,
All right.
absolutely. And there's nothing in the bill that would prohibit them from separating those children just as they do now. But what I also would say was, in terms of public safety, when you have a child who is held in an adult facility, whether it is pending transfer, whether their transfer is not pending, whether they are in adult court, outcomes are worse for them if they are in an adult
I'm not
facility.
arguing that part. I'm just trying to make sure that if we do this, we do it and do not lose sight of these other important separations that need to happen.
Absolutely.
Thank you. Thank you.
All right, any other questions for the sponsor or this panel? All right, seeing none, we'll move to the rest of the proponents. Ken Phelps. Do we have other proponents? Ken Phelps, Lucienne Parsley. Come on up. Stephen Bergman.
Good afternoon, members of the committee. This is Lucienne Parsley, Disability Rights Maryland. We're the Protection and Advocacy Center for Persons with Disabilities. I'll be brief. We are in support of this bill fully for the extension of the restrictions on restrictive housing, and in addition, fully support the proposed changes to prevent kids from being detained and confined with adults in facilities. We are continuing to get complaints from family members of children who are held for weeks at a time while they await transfer. Many, for children with disabilities, we note that very little, if any, mental health services are provided to individuals kept essentially in restricted housing. Studies have shown that confining an individual in a cell for 22 hours or more per day is harmful, can cause depression, trauma, paranoia, anxiety, suicidal ideation, and exacerbate existing disabilities. And all of that is exacerbated for children. So we would ask for a favorable report. Thank you.
Thank you. I see that we have Mr. Bergman online. Mr. Bergman, go ahead.
Thank you. Good afternoon, Mr. Vice Chair and committee members. My name is Stephen Bergman. I've been representing children charged with crimes for 23 years with the Office of the Public Defender. I've submitted written testimony on this bill. I asked the committee to issue a favorable report with amendments. SB 827 has two objectives. The first is to ensure that all detained youth pending transfer hearings are held in secure juvenile facilities operated by DJS. The proposed language amending the existing provisions of Criminal Procedure 4202 does this in a clear and concise manner. DJS may object to this language due to a lack of sufficient capacity, and although I'm sympathetic to this, it should be noted that the department has two facilities that are listed on their website as temporarily closed, which, if opened, would provide more than enough capacity. These are the Noyes Detention Center in Rockville and the Garrett Children's Center in Western Maryland. The overriding issue is to ensure that all children pending transfer hearings are safely housed in juvenile detention facilities where they will neither be in contact with adult inmates nor be subjected to solitary confinement in order to ensure this. The second objective is that all detained youth ineligible for transfer or who've been denied transfer not be detained in restrictive housing in order to meet the obligation that they have no sight or sound contact with adult inmates. While I applaud the intent of the bill, I think that there's a simpler way to craft the language to achieve the second of these objectives. It would be far more concise for the bill to say, and I've included this language in my written testimony. Any detained child under the age of 18 who is not eligible to have their case transferred to juvenile court pursuant to Criminal Procedure Section 4202, or any child under the age of 18 who has had their petition to transfer to juvenile court denied, shall be detained at a facility for children operated by the Maryland Department of Public Safety and Correctional Services. With that amendment, I ask the committee to issue a favorable report.
Thank you, Mr. Bergman. Any questions for Mr. Bergman or Ms. Parsley? Seeing none, that completes the hearing for Senate Bill 827. Senator Love will go to your next bill now,